morning. And to those of us joining us online, good afternoon, to some of you at least. Welcome to the symposium on African perspectives on international climate change law. I'm Hajer Gueldich, and I'm the Associate Director of the Human Rights Program. The Human Rights Program is a research program of Harvard Law School that seeks to inspire critical engagement with the Human Rights Project and to inform developments in the field through impartial, innovative, and rigorous research. Established in 1984, the program has been helping students, advocates, and scholars deepen and disseminate their knowledge of human rights for the last 40 years. Before I introduce Professor Newman and Professor Gueldich, I want to take a moment to thank Charles and Binyam, who have been at the inception of this conference, at the gestational phase of this conference, which came out of a conversation at another conference on international law. And it came out of a conversation about that conference and how that conference didn't include certain perspectives, and perspectives that are from the global south, but especially from Africa. And it just rolled over to, oh, guess what? The next large development, swath of development on international law is going to be, and it's going to be in climate change law, and where is Africa going to be when this development happens? So this is the conversation that led to this conference. So I want to acknowledge Binyam and Charles and thank you for the support throughout. Our welcoming remarks will be provided by Professor Gerald Newman, who is the director of the Human Rights Program. And he is the J. Sinclair Armstrong Professor of International, Foreign, and Comparative Law at Harvard Law School. Professor Newman served as a member of the UN Human Rights Committee, and he has published widely on issues of human rights law, international human rights law, immigration and nationality law, and US and comparative constitutional law. Professor Newman was the Herbert Wechsler Professor of Federal Jurisprudence at Columbia Law School, and he has been a visiting professor at the Johann Wolfgang Goethe University and has taught in universities of Leiden, Freiburg, and Tokyo. Our keynote speaker today is Professor Hajer Gueldich. She is the African Union's legal counsel. She served as an elected member of the African Union Commission on International Law, also serving as its chairperson for a year. Professor Gueldich is a professor of law at the University of Carthage, where she is also the director of the Center for Research in International Law, International Jurisdictions, and Comparative Constitutional Law. She is also a visiting professor at two universities of Angers and Rennes in France, Venice and Siena in Italy, St. Joseph in Lebanon, Laval in Canada, and the Pan-African University in Cameroon. She has several publications in comparative transitional studies, as well as in the fields of international law, AUCIL, human rights, and constitutional law. With that introduction, let me hand it over to Professor Newman and then Professor Gueldich.
Good morning. Thanks to those in the audience and those who are with us in the web audience for being here. As you've heard, I'm Gerald Newman, the director of the program. And I'd like to welcome you to the Symposium on African Perspectives on International Climate Change Law, which was organized jointly with the Center for International Law and Policy in Africa and the Dula Omar Institute at the University of the Western Cape, South Africa. We're very grateful for their close collaboration, as Abadir has just said. I'd also like to give deep thanks to our co-sponsors here at Harvard. First, the Salata Institute for Climate and Sustainability. Also, the Petrie Flom Center for Health Law and Policy, Biotechnology, and Bioethics. I'll have to get used to saying that quickly. David Rockefeller Center for Latin American Studies, the Human Rights Entrepreneurs and Incubator Clinic, and the Program on Law and Society in the Muslim World. Climate change, as we all know, is a subject of immense global importance with both generalized and locally varying impacts. Many of these impacts can be described in human rights terms. And human rights law may be one of the areas of international law that can contribute to finding solutions. But these are not only issues of human rights law, and not only issues of human concern. Human rights law is only one of the areas of international law that is needed for addressing these problems. As we discussed yesterday at the Human Rights Journal Symposium, states have differentially contributed to causing climate change. States and their populations are differentially suffering the consequences of climate change. And states have different contributions that they can make to mitigating climate change. Responding to the threats of climate change requires increased international cooperation, and we need to listen more closely to states whose voices have not carried sufficient weight in international politics and law, and the voices of the populations of those states. The states in Africa are not the only example of this phenomenon, but they provide a major and extremely important example, and we need to learn from African perspectives on this subject. We need to learn through academic dialogue, through political dialogue, and through judicial dialogue in the shaping of international law. That is the rationale of this symposium, for which I view myself as a facilitator and a listener and a welcomer, not a speaker. I thank Abadir for his leadership of this project, and I thank Kai Miller for all of his behind-the-scenes support. We'll begin with a keynote address in a moment, followed by 4 panels, and punctuated by some shorter remarks. The first panel is on the participation of African states in shaping international law. The second is on common but differentiated responsibilities and respective capabilities. Then we will break for lunch, followed by the third panel on adaptation, mitigation, loss, and damage. And fourth, on human rights and climate change, leading to closing reflections. Meanwhile, at lunch, you're invited to stay for a different but related event, the role of courts in advancing the right to a healthy environment, lessons from Latin America, which is led by our colleague, Alicia Yaman from the Petrie Flom Center, in discussion with Supreme Court judges from Mexico, Brazil, and Argentina. Thank you, welcome, and let's begin.
Colleagues, ladies and gentlemen, sound is good? Good morning. Esteemed colleagues, scholars, and future leaders, it is an honor to stand before you at Harvard School, and thank you, Professor Abadir, for your kind invitation and for your leadership. Today, we delve into African perspectives on international climate change law, addressing the profound challenges and embracing the opportunities for justice and resilience. This symposium comes at a pivotal time in Africa's participation in tackling one of the greatest challenges our planet has faced for many years climate change. As the effects of climate change become increasingly evident worldwide, Africa, a continent of diverse ecosystems and cultures, faces a myriad of challenges exacerbated by its impacts. The rising sea levels pose a significant threat to coastal communities, many of which are densely populated and economically vibrant. Meanwhile, African communities face the stark reality of droughts that wither crops and dry up wells. Yet, it is not just statistics that tell our story, but the lived experiences of individuals and communities. In addition, droughts and desertification are becoming increasingly common, leading to the loss of arable land and threatening food security for millions of people across the continent. Extreme weather events, such as cyclones and floods, are becoming more frequent and severe, displacing communities and disturbing livelihoods. These challenges are further compounded by the limited resources and capacity to adapt, making Africa particularly vulnerable to the effects of climate change. Despite contributing minimally to global greenhouse gas emissions, Africa is disproportionately affected by the consequences of climate change, highlighting the urgent need for action to mitigate its impacts and build resilience in the region. What about the African legal system in this field? For far too long, the narrative surrounding Africa and international law was one of passive acceptance. This is a result of the systemic erasure of African states from the history of the creation and use of international law, and Africa not receiving credit for contributing to the making of international law in the post-colonial era. In reality, African states emerging from colonialism actively challenged the Eurocentric foundations of international law. Today, Africa has been pioneering a unique approach to climate change law. African legal frameworks, both at the national and regional level, prioritize the adaptation of strategies due to the continent's unique vulnerability. In this regard, Africa's legal responses to climate change, including the Nairobi Declaration on Climate Change and the Bamako Convention, showcase our dedication to sustainable development, environmental stewardship, and the unique approach centered on adaptation, innovation, and collective responsibility. These legal frameworks, deeply rooted in community, equity, and intergenerational justice, address the specific needs of African nations. They exemplify Africa's commitment by emphasizing the development, financing, and transfer of environmentally sound technologies alongside regulating the import and transboundary movement of hazardous waste. Hence, this focus on capacity building and resource sharing reflects Africa's understanding that international cooperation is crucial for addressing a challenge that transcends national borders. This is further emphasized by the several legal frameworks in Africa that address various aspects of climate change, including mitigation, adaptation, and finance. These frameworks consist of national law, regional agreements, and international commitments. Many African countries have developed national climate change policies and laws to guide their efforts in addressing climate change. Regional economic communities in Africa, such ECOWAS, such SADC, have adopted regional agreements on climate change which aim to coordinate efforts among member states and enhance regional cooperation on climate change issues. Moreover, the realization of Africa's Agenda 2063 cannot be possible without proactive and collective continental efforts aimed at addressing the impacts of climate change. And in this regard, the African Union Climate Change and Resilient Development Strategy and Action Plan of 2022-2032 is a key instrument. It provides a framework for joint action and it clearly expresses our needs and priorities. Colleagues, our symposium today is more than an academic gathering. It is a call to action. African nations have long championed principles such as common but differentiated responsibilities. This principle is not merely a legal nicety. It is a lifeline for millions who face the existential threat of climate change without the means to combat it effectively. We demand a reinvigorated global partnership where the historical emitters of greenhouse gases take responsibility not just through emissions reductions, but by enabling African nations to leapfrog to sustainable technologies and resilient infrastructures. This is not a charity. It is a moral and a legal obligation. It is a repayment of the climate debt owed to the most vulnerable. And despite facing various obstacles and challenges, such as limited resource and capacity, African nations have shown remarkable commitment to addressing climate change. This commitment is evident in their active participation in regional and international systems where they have played a crucial role in advocating for the inclusion of their perspectives in international negotiations. African countries consistently emphasize the need for equity and fairness in climate action. This means acknowledging the historical responsibility of the global north for a significant portion of greenhouse gas emissions contributing to climate change. It also means recognizing the vulnerabilities faced by African countries which lack the financial resource and technological capacity to adapt to the impacts of climate change. States' participation is evidenced by how instrumental they were in the creation of the United Nations Framework Convention on Climate Change, fighting for the inclusion of principles such as common but differentiated responsibilities, which recognizes the historical burden of developed nations. However, it is also clear that the global north has historically been the greatest polluters, and as such must lead the charge in addressing the issue of their making. They must cut emissions and provide financial and technological support to its effects. Now on the issue of the due diligence and the precautionary principle. African states emphasize the importance of due diligence and the precautionary principle, rooted in our values of intergenerational equity and respect for the environment. Due diligence ensures development occurs not at the cost of our environment. Due diligence is a responsibility we hold as Africans to our ancestors and our children to protect our rich history and bountiful environment. And in this context of climate change, due diligence demands we scrutinize projects, demanding transparency and the thorough assessment of environment impact. It is the assurance that the development occurs with and not at the cost of our environment. The principle of precautionary goes further, recognizing that scientific certainty can be elusive, particularly when dealing with complex ecosystems like ours. We cannot offer to wait for absolute proof before acting when the potential harm is grave. We must work towards We must work towards proof and towards making preventative measures. And this principle empowers us as Africans to say no to risky ventures and prioritize the well-being and the health of our people. Our continent must be a strong voice in demanding stricter regulations on polluting industries, insisting on technology transfer to support sustainable development, and advocating for robust financial mechanisms to help us adapt to a changing climate. And we cannot offer to go back to being passive recipients of a pre-written narrative after having fought valiantly to have our voices in these discussions. By wielding the principles of due diligence and precaution, we can safeguard our people, secure a sustainable future, and rewrite the story of Africa. On the issue of legal pathways for adaptation and mitigation, when we look at pathways for adaptation and mitigation, African countries are exploring various legal pathways in this regard. Africa, with its unique vulnerabilities and challenges, requires tailored legal pathways to address climate change effectively. Adaptation is a key priority for African nations, given the continent's susceptibility to climate-related risks such as droughts, flood, and desertification. Legal frameworks must facilitate the implementation of adaptation measures, including the development of early warning systems, sustainable land management practices, and climate-resilient infrastructure. The African Union has been a great leader in trying to do all this, as evidenced through the establishment of agencies such as the African Risk Capacity Specialized Agency, developed to help African governments improve their capacity to better plan, prepare, and respond to extreme weather events and natural disasters. Mitigation efforts are equally important, particularly as Africa seeks to pursue sustainable development pathways, and legal pathways for mitigation should support the transition to low-carbon economies, promote renewable energy sources, and enhance energy efficiency. It is essential to recognize that African countries, however, face barriers to mitigation, including limited financial resources and technological capacity. International cooperation, as we have seen, is therefore crucial in enabling African countries to achieve their mitigation goals. Further than this, legal frameworks must ensure that adaptation and mitigation efforts are implemented in a manner that is socially, economically, and environmentally sustainable. And this requires the integration of climate change considerations into broader development planning processes, as well as the protection of vulnerable communities and ecosystems. On the issue of climate change, loss, and damage, African countries are particularly vulnerable to the impacts of climate change, including loss and damage. Today, the continent stands on the front lines of a crisis not of our making, crisis which has grown from the roots of changing climate. Rising sea levels swallow our coast communities whole, displacing millions and erasing our history. Extreme weather events cripple economies and devastate our ecosystem. These are not mere statistics, but again, the scars etched upon our continent. We face a harsh reality of loss and damage that is already upon us. These losses are not simply economic. They are a deep erosion of our cultural heritage, our livelihoods, and our very way of life. The current international framework fails to address this reality, and we need a robust mechanism for addressing loss and damage that involves financial support, technology transfer, and capacity building. And developed nations need to fulfill their responsibility and provide adequate financial resources to help us rebuild, relocate, and adapt. We need the expertise and institutional support to address loss and damage effectively. We are actively building resilience, developing innovative solutions, and leading the way in sustainable development. But the scale of the challenge is immense, and we cannot do it alone. International climate change law must evolve. It must reflect the urgency of our situation and prioritize the needs of those who are most vulnerable. Now on the issue of climate change and human rights. When it comes to human rights and climate change, the human cost of climate change casts a long shadow across Africa. Rising temperature, erratic rainfall patterns, and intensifying storms threaten the very foundation of our societies. These are not just environmental challenges, but they are also violations of fundamental human rights. Millions face food insecurity due to climate-induced droughts, jeopardizing their right to life and adequate food. Rising sea levels that we spoke of earlier are threatening to displace families and jeopardizing their right to housing and cultural heritage. Extreme weather events disturb livelihoods and healthcare access, undermining the right to health and a decent standard of living. International climate change law must recognize this human dimension, and developed nations have a responsibility to protect the human rights of those most vulnerable to climate change impacts. However, as Africans, we need to be the first to advocate for a rights-based approach to international climate change law. This means prioritizing equity and fairness. Developed nations must take the lead in reducing emissions and provide financial and technological support, as I said. In Africa, empowering vulnerable groups is also paramount. Women, children, and indigenous communities often bear the brunt of climate impacts. We need legal frameworks that guarantee their participation in decision-making and access to climate change and justice. Climate strategies should be designed and implemented with respect of human rights, ensuring a just transition to a low-carbon future. Loss and damage mechanisms must fully consider the human cost of climate change, especially for Africa, a continent with a rapidly growing population. Food insecurity due to climate shocks will have a devastating impact, with millions more at risk of hunger. Rising sea levels threaten densely populated coastal areas, displacing entire communities and creating a massive human rights crisis. Climate change will exacerbate existing social and economic inequalities, disproportionately affecting the poorest and the most vulnerable. Strong legal frameworks with a clear accountability mechanism are crucial to ensure polluters and have responsibility for the human rights harms they cause, and to provide the resources needed to help Africa address the immense human costs of climate change. I emphasize to you once more, esteemed colleagues, that Africa cannot and should not be passive victim of international climate change law. There is a need to actively integrate human rights principles into our national climate strategies and promote the regional cooperation. The last point of my speech will tackle the ICG advisory opinion. As you know, justice lies at the heart of our discussions on climate change. In pursuit of a more active role in addressing climate change law, the African Union took a significant step. And as you may already know, in July 2023, the International Court of Justice invited states, including the African Union and other international organizations, to submit written contributions on the legal questions regarding climate change raised by the United Nations General Assembly. The request looked for the emphasis of the role of advancing international law to safeguard current and future generations of generals of crisis arising from climate change. The African Union has made its submission in which it emphasizes issues of which I covered here today, with regards to differentiated obligations and the necessity to consider the growth and prosperity of African nations. Legal experts, including scientists, played a crucial role in shaping our submission. Let me here take the opportunity to congratulate and thank the professors who participated in these efforts, especially Professor Makan and Professor Jalou and Professor Hilal. Going beyond its submission, the African Union commendably organized an online capacity building workshop on 8 and 9 March 2024. And this workshop provided valuable tools and resources to participants from African member states. This workshop, led by legal and scientific experts, equipped participants with the knowledge and skills to draft strong written contributions to the ICJ. The advisory opinion, a crucial opportunities for Africa's voice to be heard on the legal aspects of climate change. The AU expects that the opinions will provide legal clarity on key issues, differentiated obligations, and loss and damage, paving the way for a just, sustainable future for Africa. In conclusion, esteemed colleagues, today we stand at a crossroads in our global response to climate change and climate crisis. The current international climate change regime, despite its well-intentioned origins, has proven inadequate in addressing the specific challenges faced by Africa. In Africa, we are experiencing the devastating consequences of climate change despite our minimal historical contribution to the problem. The upcoming International Court of Justice advisory opinion is a positive step, but it represents only one piece of this ever so convoluted puzzle. For a truly equitable and effective response to the climate crisis, we need a more comprehensive legal framework, one that squarely addresses the unique vulnerabilities of Africa and other regions on the front lines of climate change. In light of this, I propose the establishment of a specialized international court on environment, competent in matters of ecocide. This court would possesses specific expertise in environmental law and climate change issues, equipped with the jurisdiction to address the specific challenges posed by our changing climate. It would provide a dedicated forum for resolving disputes between states and holding polluters accountable. Moreover, this kind of courts would play a vital role in interpreting existing environmental treaties and developing new legal principles to address emerging challenges of our time. An international court on the environmental would not replace existing institutions like ICJ or ICC. Rather, it would complement them by providing specialized expertise in environmental matters. The creation of such a court would send a powerful message of international community's commitment to environmental protection and climate justice. It would provide a critical tool for holding states accountable for their environmental actions and inactions. More importantly, it would offer hope for a more just and sustainable future for Africa and for the world. By establishing a specialized international court on the environment, we can ensure that the voices of the most vulnerable are heard and their rights are protected. It is time for the international community to listen attentively and respect the voices of African nations and other vulnerable regions. Our experiences, our struggles, and our insights are invaluable in shaping a sustainable future for our planet. Together, we can forge a new path forward, one where justice, equity, and environmental stewardship guide our collective journey towards a sustainable and just world. Thank you so much for your kind attention.